Are you Mr. Shively?
Yes. Yes, sir.
File number 242170. Appearances for the record.
Good morning, Your Honor. For the record, Dan Bingham.
And sir, I don't believe that I have an appointment of an attorney for you. Has the Office of Assigned Counsel reached out to you? Have you talked to anybody?
No, sir.
All right, so here's what we're gonna do then. Get you over to OAC or get the file over to OAC again to make sure that you have an attorney appointed. And then the date scheduled for July 22nd, we'll continue that on to a pre-exam conference or probable cause conference. So hopefully an attorney will be hired. No need for witnesses. I'll find good cause to waive 21 days, although it looks like 12 weeks already done. So, Mr. Shively, what's going to happen is basically, I'm going to take the file down to Office of Assigned Counsel to make sure that an attorney is appointed for you and that they get in contact with you within the 3 days of appointment. Then we'll come back again on the 22nd. I believe it may be by Zoom as well. So, okay.
All right.
All right. You're all set. Have a good day and be well. In the matter of People versus Cronk on 243780.
Morning, John Cowden on behalf of People.
Morning, Your Honor. Rado Farrell on behalf of Mr. Your Honor, you have two cases. You had another one that we had a peck on. And we were going to talk about them both today.
Right. No, I remember the conversation, but I don't see the file here, so I don't think I got one. But I remember what we talked about.
We haven't been able to negotiate, Judge. We're still putting the two cases together, and I'm going to have to speak with Mr. Stevenson, who's unavailable today. We would like to waive the 21 days on this case, which is 3780. We already waived the 21 days on the other case, which was 243222 FY.
Right. We weren't able to, we're not going to, you don't want to keep the 24th. I thought we discussed keeping the 24th on.
That's the other one.
That's on Cronk on 243222.
I was hoping we could use that to resolve the case, Judge, but we're not going to be ready. And I don't see, I would prefer to adjourn so I can negotiate before we actually see if a prelim is going to be necessary.
All right. All right. So we'll just adjourn the 24th altogether again.
Thank you.
Mr. Cronk, on this case, you do have the right to have a preliminary exam within 21 days. On the other one, I did find a good cause to waive in order to take it to the 24th. However, given what your attorney has said, that you wish to, is it my understanding that you wish to waive your right to have a preliminary exam within 21 days?
Yes, Your Honor.
All right. Court determines a waiver of 21 days being knowingly, voluntarily, and understanding provided. We shall adjourn July 24th on both cases. And then reset. Are we going to reset as a probable cause conference?
Yes, Judge.
All right. Is there anything further?
No, Your Honor, thank you.
All right. Ron shall be continued.
Thank you, Your Honor.
In the matter of People versus McLaren 243880.
Good morning again, Your Honor. The record being in order for the people.
Good morning, Your Honor. David Roby on behalf of Mr. McLaren, who is approaching, will be standing to my immediate right.
Your Honor, Mr. Barrera is the code defendant.
That's on number, on file number 243879.
Again, Your Honor, Dan Bingham.
And good morning, Your Honor. Kelly Ellsworth appearing on behalf of Mr. Barrera, who's present with me.
Okay, and what are we doing today?
Your Honor, I believe both these matters are going to continue to.
That's correct, Your Honor.
That's a correct statement.
So I have that on the date of the 24th at 10:30 a.m. Does the court need to be made aware of anything?
Nothing from Mr. McLaren.
Defense has all discovery.
No, Your Honor, I just filed an appearance on this yesterday. I do not have a copy of the discovery. However, I believe in the next 12 days, I'll have sufficient time.
Discovery that the people have, is it complete?
I believe so, Your Honor.
So you've gone through it to know that there's no recordings, there's no anything that pops up last minute that wasn't known.
I don't see any of that, Your Honor.
All right, then. We'll continue the preliminary exam. Bond shall be continued unless there's anything else.
All right, thank you.
Nothing additional, thank you.
All right, thank you. In the matter of People versus Beckman, 233924.
Morning, Your Honor, John Calvin on behalf of the people.
Hello, Herman, on behalf of Mr. Beckman, Your Honor.
Yeah.
Your Honor, I just asked at this time that if we could just keep this, continue on to the preliminary examination.
Discovery's all been held or been complete.
Yes.
I have it on 7/24 at 10:45. Mr. Beckman is is on day reporting, is that correct? No.
That I don't know. No, tells me he's not.
And I can tell from the notes on 7/5. Anything further from the people?
No, Your Honor, thank you.
We'll continue then the preliminary exam.
Thank you.
Bond should be continued. People versus Madison on 243442.
Morning, Your Honor, John Calvin on behalf of the people.
Eleanor Herman on behalf of Mr. Madison, Your Honor.
Okay, and what are we doing today?
I'm sorry, what was that, Judge?
What are we doing today?
Your Honor, we'd just like to continue on to the preliminary examination. There are other cases that Mr. Madison has, and we're going to try to, it looks like something may have been double charged. We've got to look into that. At any rate, Your Honor, and we're going to try to work that out before the prelim. I'm expecting that we won't have to hold the prelim.
Is there anything else on today?
That's all we're doing today.
All right, continue preliminary exam.
Thank you, Judge.
Thank you.
Just go right into your sentences.
In the matter of People versus Hicks on 242747. Appearances for the record.
Good morning, Your Honor. Eric Coltrane on behalf of Mr. Tristan Hicks. He's the defendant in this matter. He is standing to my immediate left in the jury box.
All right. Any additions, subtractions, or deletions?
We have none, Your Honor. Everything is accurate as far as the report is concerned.
Anything else? Way of execution.
Yes, thank you very much, Your Honor. Mr. Hicks is standing before you. This is an assault for crime. I will tell you that I've talked to Mr. Hicks quite a few times after this event took place. And looking at his history and things of that nature, Your Honor, you can see that there have been some bad decisions made by Mr. Hicks in the past. However, I really think he has a very strong support system. He is giving a job or had a job. Everything was on the right path. He is on parole too. Just to let you know, Judge, he is going to have supervision one way or the other. We understand the CST classes. I agree with the CST classes. Talk to Mr. Hicks about those. It's recommended 90 days with credit for 58 days served. The only thing we would request, Your Honor, is to possibly take a look at that and allow him time served for the 58 days he has served. Let him get back out, be with his grandmother who's sick, of course, who he lives with right now. Get a job and just try to get his life back on track. He is on parole. He'll be supervised. He also will be doing the CST classes with Ms. Joseph, which I think will be beneficial. Thank you very much.
What's his parole officer? Who is his parole officer?
Ms. Vaughn. Ms. Vaughn.
Oh, okay, Ms. Spalding. All right. And did she refer you over at all for this case on anything? Has she talked to you about referring, or what's gonna happen?
She's basically waiting on to see what you guys gonna do.
My understanding that you had your second parole violation. Correct.
Yeah, the first one, I didn't know it was a violation by my, I'm on GPS, teller, and it had quit working. And she said that it counts as a violation, and I didn't know that. I had to put another one on my leg, but she counted that as a violation.
So you don't know if Miss Spalding's gonna discharge you or seek that you be discharged? Or would you be you'd be placed right back into DOC, correct?
Well, I think I'm not sure. I haven't talked to her. She haven't said anything. She just saying whatever you guys decide to do with me, then that's the last thing she told me. I still got my GPS on my leg.
Noting that he remains on supervision from the Department of Corrections. $58 days, credit for 58 days. This is with the understanding that upon release, within 5 days, you must contact CST counseling and be enrolled. All right. Now, should I find out that you are not completing, you're not participating, or you haven't enrolled, then the alternative will be the 275 days. So we're clear on that. The only reason why I'm letting you know now is because of getting you involved in CSD counseling. I understand from some of the statements that that you made, I know you have you need to work through some things, trauma that you need to get through. And you need to address that, or else you're gonna be right back to where you are with what you've done. So the idea is to limit you coming back through. So you're still responsible for the fees. There's no fines associated with it since you've been in jail. So as long as we're clear, you don't complete CST counseling, the 26 weeks to partner abuse classes, then the alternative will be the 275 days.
Okay. And where do I go?
Or actually, it'll be
For the classes?
It'll be 315. Okay.
Thank you very much.
Any question there?
In the matter of People versus Jones on 232364. If someone from, this is the sentencing on the probation violation. Okay, Mr. Jones, you have a seat. We'll wait for Mr. Yancey to get back. Okay. In the matter of People versus Lee on file number 24510.
Good morning, Your Honor. Kelly Ellsworth appearing on behalf of FJ Lee, who's present with me.
Are there any additions, subtractions, or deletions?
No, Your Honor, just allocution at the appropriate time.
All right, go ahead.
Your Honor, we were here back, I believe, on May 31st, before Your Honor for sentencing, and there was some just allocution with regards to the deferred sentence pursuant to the Spousal Abuse Act. I know that the agent indicated that he was not eligible for the deferred sentence because of a prior assaultive related conviction in 2022. However, I do believe that he would be eligible. The statute defines an assaultive crime. It's within the statute. I could read it aloud, but it's under Section 8. And none of the definitions in 1, 2, or 3 would cover any type of prior conviction that my client had. He was in the armed services and was discharged from the military, and it was like an administrative action, is what my understanding was. So I believe that he would be eligible for the deferral. I know that the report indicates that my client is not remorseful. However, he was able to allocute for himself as well as I did, and I'll just incorporate that by reference, and that he is certainly remorseful for his actions, and that he will have certainly any communication that they would have in the future, because they do have children together, would be civil. I would just request that the court adopt the recommendation with the deferred sentence pursuant to the Spousal Abuse Act. And then on item number 14, my client does have a medical marijuana card. So he would like to be able to treat with that while he is out on probation, if the court so sentences him to that. And we have no objection to any of the other terms and conditions.
Anything you want to say, Mr. Lee?
No, just what he said, 100% true. I'm communicating peacefully with Ms. Sims as well. And I just want to be able to see my children, so keep everything peaceful.
Did, I noticed when I was going through that you were treated down in Florida at the VA, but you were not receiving services up here. Why is that?
The paperwork was being held up. I actually, they had to transfer my packet from Florida to Michigan. And so they just got it set up to next week is when I'll get my treatments for the clinic here in Saginaw, Michigan.
You were on medications down there. You're not on medications up here.
I wasn't able to get a refill yet until I get my first appointment here.
What the medication you were on, then you were not weaned off that, you just stopped that?
I wasn't able to get it.
How long have you been off it then?
I can't tell you. I can't remember the last time I had.
So you haven't seen a doctor since you've been up here? How long have you been up here again?
Almost 7 months, 8 months. Oh, no, it's been since last year, Your Honor. So around July, it's almost a year, over a year.
You also saw Ms. Joseph at CST Counseling on pretrial programming.
Yes, sir.
You did not accept responsibility when meeting with her as well, did you?
That was a mistake there, Your Honor. I was, once again, not in my right mind, and I apologize for that.
Did you say mistake?
Yes, Your Honor, that was a mistake on my behalf of saying the wrong word choices to her.
Well, I think those word choices were probably accurate, is what you believed in at the time. What do you mean a mistake?
Of my word choice saying that I did nothing wrong. I don't want to be a little boy in that aspect, Your Honor. I want to be a man and admit my wrongs and face my consequences.
Are you just
And
doing
become
that
better.
now because you're being sentenced? Is that it? And you, in fact, I mean, a mistake would be you have a briefcase and you mix it up with someone else's briefcase and take it. That's a mistake. Using your word choice as a mistake is not. It's your own choice to use those words. So the words you used, I believe, were the accurate feeling of how you are at that time. Tell me I'm wrong.
I would never say you're wrong in that aspect,
No,
Judge.
it could be. I wasn't there. You were. What words did you use?
The word choice that I used that was a mistake on my behalf is saying that I did nothing wrong when I wasn't trying to face what I did.
So you come up here, you were on medication to address mental health issues. You have not renewed that script. You're telling me that it's taking a year to get your file transferred up here. Is that correct?
No, Your Honor, I'm telling you that it took that year because I was dealing with my children that I haven't been able to see. And I put my stuff off to cater to my children first, Your Honor. My wife is active Air Force and my daughter and her son were with me and her grandmother between while she was deployed. So that trumped me going to get services.
So you were living with Miss Sams at the time?
Correct. I don't know.
You recall the case.
Thank you, John.
In the matter of People versus Hutchins on 242871. Joshua Hutchins.
Mr. Gonzalez.
It's on a GPS tele around.
I think Gonzalez is stuck outside. He's covering for Solo.
And then People versus Stacy on 242110. Appearances for the record.
Good morning, Your Honor. Aaron Coltrane, on behalf of Mr. Stephen Stacy, he's the defendant in this matter. He's standing to my immediate left in the jury box.
All right. Any additions, subtractions, or deletions?
There are no additions, deletions, or corrections, Your Honor. Everything is accurate in the report. And no addition.
All right. Go ahead, Estelle.
Thank you very much, Your Honor. It's a little bit tough for me here, Judge. Every time I look at Mr. Stacy, he's extremely polite. He has a nice smile. He shakes my hand. He seems to me as a very straight and narrow, nice individual. However, look at the pre-sentence report, and I see that there's a list of crimes that he's committed in the past. And clearly, he's in the jury box right now. So I started talking to Mr. Stacy about it, and I realized that he started drinking at an early age, about age 14, which correlates, of course, when he got in trouble in 17. And then over the last years, every single one, if not almost every single one, has to do with alcohol. I talked to Stacy about it. He's a different individual, and I think he recognizes that he spent a lot of time without his freedom due to that. And I really think, Your Honor, that as a sober individual, Mr. Stacy can be a really good, intelligent member of society. He can benefit and do big things, but the alcohol is an issue. We did have a case of Judge Jones, Your Honor, and I want to let you know that we do have Mr. Stacy set up for DOT in-house. Once he completes the in-house treatment, he will then go to his overlooking facility. The rescue mission, I believe, is where we were going to have him set up. I understand the recommendation is for additional days, which of course, Mr. Stacy and I do understand. It would be 93 with credit for 67 days. The only thing that I would ask, Your Honor, is if at all possible, if there's a bed open at DOT, to possibly release him early strictly to DOT in-house. And if not, of course, Mr. Stacy will serve the remainder of the time as recommended, and he will go to DOT afterwards.
Is he still on probation then with Judge Jones?
With Judge Jones, Judge Jones held it in abeyance, gave him 365 and held it in abeyance.
So he's not on
He
probation.
is not going to be on probation.
So there's no controls over him once he goes over. And then,
There is no opening.
so if I look at his record, going back, so he had with, and it's all with family, right? His sister or his mom.
That's the majority of it, Your Honor.
Yep.
Which is why he does not have a place to stay.
Right. Well, that's because you said he always seems to be so respectful, so nice, and he has been in court. That I guess goes to the fact that outside of the home, he's this angel that has all potential in the world, but when it gets inside behind closed doors, he's the terror that has caused him to be in the situation that he is now. So back in 21, he was sentenced to do solution behavioral health. He was discharged without success. 22 cases were dismissed. He was sentenced. He did jail. And it sounds like it was just a credit for time served. And then in 23, we're right back to where we are. And those are with the cases, it looks like it was with Judge Jones. So that seems to be the issue. And I don't think anywhere says what it is and why he's trying to, and what's causing him to act and not regulate behavior that he's.
Yeah, I will state that he was treated previously counseling when he was younger, and he did have some, I believe it might be listed in the assessment, but he did have, I believe, oppositional defiant disorder younger, and he does needs some help with that.
Right.
Of course, that mixed with alcohol.
No, right. Under the DSM, it's oppositional defiant until they turn the age of 18, and then they just become fine. Well, no, they just become an ass. That's the issue. So how do we get it to a point where, Mr. Stacy, you're not the terror that you are? So I guess you have to decide how we're gonna get to whatever is causing you to lash out the way you do. Because you have been, every time I've seen you, which has been in court, you have been respectful. Every time I look at you, I'm wondering why you're even here. It looks like you either should be in some trade, some college, working, not in the outfit you are in now. So we're gonna do this. Since Judge Jones didn't place him on probation, I don't have a lot of time, that's the issue. Because of the plea arrangement that was reached, rather than giving an attempted interfering, which would give me a year to work with Mr. Stacy, he pled to a charge which only now gives me, what, 23 days in jail. So here's what we're going to do with those 23 days. 67 days, let's give credit for 67. 9 months supervised probation. 75, 50, 50 and fees, 30. I'll waive all those fees completely. If you successfully complete CST, And then you also need to comply with Judge Jones, because let's put it this way. If you don't do it with what you're supposed to do with CST, then Judge Jones has that year. So that's how we're gonna piggyback the two cases, all right? So just so we know, and then Miss Joseph, who was online, will go back with her. You had Tuani, I believe, over at Solutions Behavioral Health. Remember him?
No.
Okay. Did you even go to Solutions Behavioral Health? Outside of the lady.
He was ordered to go to job for about 6 months ago, and he had the opportunity to be away from it.
Right. No, I know. But let's start out that way. Then you'll turn it to-
No contact, Your Honor?
No contact. All right, Mr. Stacy, good luck with everything. Now is your time, I guess, right? You got the whole world ahead of you. This is not the destiny that I don't think the Lord has chosen for you, right? Right. All right. Good luck. Yeah, color vote, and refrain. This line is going to explain to you everything you're going to do to comply.
I believe he's going to be in there during times and opening it up. And that, they had a waiting list as of yesterday.
Okay. And Jones.
I'm ready.
People versus Jones on 232364. Appearances for the record.
Your Honor, Anthony Gonzalez on behalf of Craig Jones, who appears to my left before you.
And what are we going to do today?
Your Honor, proceed to confidential information violation sentence report. In this matter, Judge, my understanding is a recommendation for him to be discharged without improvement as long as he pays the remaining $80. He did pay the remaining $80 yesterday. And I would ask the court to follow that recommendation or consider following.
Yeah, here's what I have. So he was on other occasions where he didn't comply with what this court asked him to do. I believe you were in jail because you didn't comply, correct? Oh, I held you in contempt. And then I said, okay, well, you got to complete with Miss Joseph, right? Here's what I got from Miss Joseph. Well, I'll paraphrase it. You did the same thing you did before. You're not going. So why are you so resistant to change?
Because I have nowhere to sit down and talk in a public place except for outside. I mean, I'm trying to talk to a rescue mission in one of those offices. If they allow me.
Last time you said, well, I was
outside.
I had a Reconnect Michigan meeting at Delta College downtown at 10:11 on Tuesday, when that's what I think.
Yes.
But you were always saying it's the bus.
I was
Or you
on my
have
way
to
to the
work.
bus station going home.
I believe Miss Joseph said she would meet with you in person too.
I didn't hear it from her.
So 22 intimate partner abuse, although it was dismissed. 22 intimate partner abuse allegations, although it was dismissed. I had one of them, Judge Clark had one of them, and they came in contact with the police and the R&O. In this case was afterwards. So I'm not going to discharge you without you completing CST counseling. I'm going to extend you out 9 months. Complete CST counseling must connect with Ms. Joseph within 5 days, again, to resume your classes. If for any reason you fail to attend, you need to be here to say why. Anyway, you're not gonna be able to attend the classes if you get permission of the court. And so failure to do it will just result.
Your Honor,
Yes, Ms. Joseph.
I'd like to see him in my office Monday at 11:30.
Got that all done. Monday at 11:30. What's that?
I just want to make sure you knew where it was at, Your Honor, so
Okay.
he does, so we're on it.
Here we are.
Thank you.
Good luck, Mr. Jones.
Thank you.
Thank you, Ms. Joseph. Recalling Mr. Lee on 24510. I need, so when I ask for proof of DA appointment, I'm not sentenced today. Also, mental health evaluation. Ms. Joseph, who do you want to do that? Ms. Joseph? I'll get back, when she gets back, so I'm gonna adjourn today, so those two things are done. Because I don't believe that you were taking your meds. And until there's a plan in place, I'm not sentencing you. You're asking that this court grant, even though the people recommended the deferral. If I'm gonna do that, he needs to have in place that he's actually gonna take the steps necessary so that he doesn't repeat coming back through. The fact that what he did in front of children is grounds enough where he should just be sitting there. So we're gonna reconnect once I get those two things, and then we'll sentence.
Thank you, Your Honor.
Yeah, we can start.
Okay. Is Hutchins here?
Your Honor, no, I tried to.
Okay. People versus Hutchins on 242871. Transfer the record.
Your Honor, Anthony Gonzalez, for attorney, I need to so on behalf of Joshua Hudson. Your Honor, I have no explanation for non-appearance today.
All right, defendant failed to appear, bench warrant, hold, removed.
Thank you.
That's it. No, it's not a jail. Kenny Wright.
In the matter of People versus Pendleton on 241686.
Good morning, Your Honor. Jane Wainwright on behalf of the people.
Good morning, Your Honor. Kenneth Wright on behalf of Mr. Pendleton, who's standing in the jury box today. This today's set for prelim, Your Honor. I believe the prosecutor has the same thing.
Well, Judge, the victim in this case has not appeared this morning, even though she was served a subpoena. So the people are unable to proceed on count one, the felony offense. We are still asking to proceed on the misdemeanor counts 2 and 3.
Okay. Mr. Wright.
I, of course, move to dismiss the felony account. There's a felony pending for Mr. Pendleton with the prelim on July the 19th. I won't address the bond this time.
Right. So as to count one, that will be dismissed. And then, you have discovery on the other.
Yes, I do.
And we will continue, whether it be set for a bench trial, that way, jury trial, or a pre-trial, I'm not sure, but for final pre-trial.
Thank you.
Thank you, Your Honor.
Thank you.
Yeah, you ready to go on the other one?
Yeah, I'll see your.
Brooks is in the back.
And then, in the matter of People, did you need to see Ms. Brooks first, talk to her? All right. You all set? Okay.
Yes, there.
The matter of People versus Brooks, 242193, transfers for the record.
Morning, Your Honor. John Cowden on behalf of the people.
Kenneth Riley, Ms. Brooks, I believe the prosecutor has a statement to make.
Your Honor, today is the date and time for exam. At this point, I have no witnesses present and will be unable to proceed.
Mr. Wright.
Based upon the statement of Assistant Prosecutor, I make a motion. It's time to have a matter dismissed. Understand the people of prejudice.
Matter will be dismissed without prejudice.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
Take care, man. In the matter of People versus Jones, 234075.
Here, Major Ackerman, there.
Patricia Solomsky, on behalf of Mr. Jones. Today was the day kept up for preliminary examination of this case. I had occasion to discuss that length, the nature of preliminary examination, what people would have to prove at the examination. I'm confident Mr. Jones understands that, and as a result of this time, we understand the case would be bound over and was ready to be a preliminary examination. Would you understand everything I said? And it's accurate? Thank you.
So, sir, I'll read to you basically the same thing that your attorney's already said to you, that you do have the right to a preliminary exam where it must be shown that a crime was committed and that there is probable cause existing to charge you with the crime. It's a little bit of evidence. You're still presumed innocent, but the people need probable cause in order for it to continue to circuit court. By waiving that hearing, meaning you will not have this hearing today, that now you understand you're automatically bound over to circuit court for all future proceedings. I do agree with that. Is that correct? The court then determines the waiver to be knowingly, voluntarily, and understandingly provided, and we will present the bind over for the party signature. Is there anything else?
No, Your Honor, not at this time. Thank you.
All right. On to okay.
Thank you very much.
Yep, take care. Good luck, sir. In the matter of People versus Brock on 243031.
Good morning, Your Honor, counsel. For the record, being in order for the people.
Vice President, on behalf of Ms. Rob, who is present, your virtual judgment.
Okay, and what are we doing today?
Your Honor, it's my understanding we're continuing to examine. People have one witness, will not need to sequester any other.
Okay. All right, let us know. Let me also then, is Mr. Herman, who went to Mr. Herman?
All the word you went to.
You might be in the hall, but I think Mr. Your Honor, I want to dismiss it, so.
You can call up the first judge.
All right. Oh, I need Mr. Herman.
Okay.
The matter of People versus Pippins on 243256.
Here, Major Ackerman.
Laura Herman, on behalf of Miss Pippins, Your Honor. She's outside in the hall with 3 kids. So obviously, she can't come into court. She has no one to watch.
Your Honor, the victim is present, his name is Andrew Blackman, and he would like to dismiss the charges, so I will call him to witness.
You waive her presence, then?
Yes, I do, Your Honor.
Go ahead.
Sir, when you get to the podium, could you raise your right hand? You do solemnly swear to tell the truth. Nothing but the truth, so help you God.
Can you say, spell your name for the record?
DeAndre Blackman, DeAndre.
And you know Shantaria Pippins?
Yes, sir.
How do you know her?
Okay.
And you are the alleged victim in this case?
Correct.
And you want to bring home charges today?
Correct.
If anybody threatened you or promised you anything to do that?
No, sir.
I have no question.
Mr. Herman?
I have no questions, Your Honor.
That'll be dismissed without prejudice. Very welcome.
Thank you, Judge.
Recalling Brock 243031. Any preliminary matters before we begin?
Just one, Your Honor. Again, it's a single witness exam, no other listed witnesses present. I have advised counsel, and I would place on the record that if the proofs come in as anticipated, people would be moving to add second charges this week. With that, I'll call the first witness. People will call Officer Rebecca Hines.
Officer, you could approach me and I have to pause right by the black microphone and raise your right hand. We do solemnly swear to tell the truth, the whole truth, nothing but the truth.
I do. Good morning.
You're with us. Thank you. Officer, good morning. Your full name for the record,
Rebecca Hines,
current occupation,
police officer,
with what
Saginaw Police Department,
city of Saginaw?
City of Saginaw.
And how long have you been?
About 6 years.
So if my math is correct, back on June 2nd of this year, it's sold.
Yes, sir.
Were you working a shift there?
Yes, sir.
Okay, you're not, working.
I work 6 o'clock, 6 p.m. to 6 a.m.
Okay, I want to direct your attention to the early morning hours and stuff, sometime around 38. Did you have occasionally involved in a traffic stop?
I did.
And do you recall where the traffic stop was?
It was around Union and I can't remember the other crossroad.
Okay. In any event, was it in the city of Saginaw?
Yes, sir.
Okay, we can agree that's the Saginaw County, Michigan.
Yes, sir.
Is the person that, did you have occasion to make contact with the driver of the vehicle that stopped?
Yes, sir.
Just for the record, were you working alone or with a partner?
With a partner.
Okay, the partner's name?
Isaac Hines.
The person that, did you make contact with the driver at some point?
At some point, yes, I did.
Was the driver the sole occupant, if you recall?
There were 2 people inside of the vehicle.
The person you made contact with is the driver. Is that person present in court?
She is.
Would you indicate for the court where she's located, where she's wearing?
She's sitting right over here with a pink top on and there's her top.
Thank you, Your Honor. As a result of that interaction, were other investigative steps performed at that scene?
Yes.
Specifically what?
Well, my partner was mostly dealing with her and I dealt with the passenger on scene. And then we did end up conducting an investigation for OWI.
Okay. As a result of that investigation, was this defendant transported somewhere else?
Yes, she was transferred to the hospital.
Okay, when you say the hospital, which hospital?
Covenant.
And we can agree that's the Saginaw, Michigan as well?
Yes.
And we can agree that's the Saginaw County?
Yes, sir.
When she was transported to the hospital, what took place?
She had to go to the bathroom when we got in there. So generally, if people are acting appropriately, I can take them out of handcuffs, let them go to the bathroom. And a common courtesy to people, because we're all human.
Let me stop you there, just to perfect the record. Why was she taken to the hospital?
For a blood draw.
Oh, thank you. Continue.
So I had taken her out of handcuffs, let her use the restroom, and I had talked to my partner on if she was behaving appropriately to leave her out of handcuffs, because if not, then we will place her back into handcuffs to make sure she's safe and that other people are safe as well.
Okay, so your partner, the other officer, Hines, was present on the scene as well?
Yes.
Oh, present at the hospital?
Yes.
After you had that discussion, what if anything happened?
Well, he had told me that she made statements about trying to pick out the back window. She never acted on those statements, but he made it aware to me just in case if anything had started escalating.
Honor, objection, hearsay.
Not offered for the truth.
So I had kept that in mind while I was dealing with her. Over the time of trying to get the blood draw, she had become more verbally aggressive. So I said, at this time, we're going to.
Just for the record, summarizing, how did she become more verbally aggressive and what led you to that conclusion?
Mostly it's the word usage becoming start being vulgar. I don't remember her exact verbiage, but she was mad because we had arrested her for OWI.
Were those vulgarities directed at you and or your partner?
Yes.
What happened after that?
I had said, let's just put her back in handcuffs because we know how it can escalate very quickly. So we went to go put her in handcuffs. She started saying, no, pulling away from me. And then we had to escort her to the ground so that we could put her in handcuffs properly.
When you say we?
My partner and I.
Okay, so both Officer Hines?
Yes.
And both of you were involved in taking her to the
Yes.
ground? And were you able to get her handcuffed ultimately,
Yes,
but not without some resistance?
correct.
And after you got her handcuffed, what if anything?
She sat in a chair. We didn't have any other real issues. She was still verbal. She made it aware that she didn't want anybody to touch her, which, you know, unless we had to do the blood draw, obviously, or she wanted medical attention because she said she was pregnant. So we got her that medical attention. We had doctors look at her, make sure she was okay, and then we took her to jail.
Now, going back to when you were going to place her in cuffs, had either you or your partner in your presence informed her of that?
Yeah, we said out loud that we were gonna place her back in handcuffs.
And those commands were issued by both of you?
I can't say what he said. I don't know what he said specifically, but I know what I said.
But in any event, he was also involved in this.
Yes, we were both walking up to her at the same time.
No further questions, John. Thank you.
To start, when you initially had contact with my client, he was compliant during the order, correct?
I didn't deal with her mostly for the OWI stop. My partner did. I dealt with the passenger.
But as you're aware, there weren't any issues when she was completing the sobriety tests for the OWI investigation.
I can't say just because I wasn't a part of that.
So you're not aware of any issues that occurred during?
Based off of what my partner had said, he said that she was becoming verbally aggressive in the backseat. That's the only information that I have.
If she was non-compliant during that, it would have been in the police report, correct?
If my partner put it in there, I didn't witness it, so anything in my police report, it's what I experienced.
Would it be normal practice to put something like that in the police report if the person was not compliant? Were there any incidents, were you in the vehicle when she was being taken to Covenant Hospital?
No.
So she was in your car?
I believe so, yeah.
Did you arrive to the hospital at the same time?
Yes, ma'am.
And when were you part of bringing her into the hospital with your partner?
Yes,
ma'am. And was she compliant when she was getting out of the vehicle, walking into the hospital?
Yes, ma'am.
And how long was she waiting in the hallway in handcuffs before she asked if she could use the restroom? How did that?
It was right when we walked in.
And then you two decided together that she was compliant, behaving appropriately enough so that you could take her out of handcuffs.
I had taken her out of handcuffs initially to let her use the bathroom, just because obviously everybody's human. We don't want her having an accident in the hospital. So I took her out of handcuffs. I asked my partner at that point, you know, is she compliant enough to where we can keep her out of handcuffs? He said that she was making these statements, but did not act on it at that time.
But she was compliant enough to let her out.
Correct. I felt comfortable. Yes.
And then when she was taken to the waiting area, she was not placed back in the handcuffs, correct?
Correct.
And do you know how long that period was that she was out of the handcuffs?
I do not.
Would about 20 minutes sound accurate?
I'm not sure. I'd have to look back at timestamps.
Do you recall making any statements that might have been agitating or coming off as insensitive while you were at the hospital speaking with Ms. Brock while she was placed out of handcuffs?
I don't think so.
Do you remember making a statement of along the lines of, it's 100% ghetto, driving past your boyfriend's house is super ghetto? Do you remember stating something
Oh,
along
yes.
those lines?
She said that what we were doing was ghetto. And I said, yes, this is ghetto. I was agreeing with her because the situation was in fact ghetto.
But you were saying she was ghetto for driving past her boyfriend's
The
house.
situation was ghetto, yes.
And do you have any sensitivity training when it comes to dealing with the public?
Speak honestly.
Understood. And at that point, that was when you felt that she became agitated.
It was a little bit after that, yes, because she continued to make statements such as that.
Did you ever make any direct verbal commands to my client in order to place her in the handcuffs?
I'd have to look at that.
So you don't. Is there a certain procedure that you utilize in order to place a person in handcuffs?
I guess I don't understand.
Do you have a routine or practice? Do you tell them to stand up, put their hand behind their back? Is there a specific procedure?
It depends.
Depends on what?
Every situation is different.
Well, in this specific situation we're discussing, she's in the hospital already. She's been out of handcuffs for over 20 minutes. What procedure would you need to use in order to place her back in handcuffs?
We would It depends on if she's standing, it depends on if she's sitting. At that point, I don't remember if she stood up or if she was still sitting.
But you don't remember if she was standing or
I
sitting,
don't.
but you, so then how specifically did she resist?
She started yelling, no, 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 and pulling her arms away from me.
How long did it take to place her in handcuffs?
Maybe a minute.
But she was placed in handcuffs and then sat back in the seat to wait for
Yes.
the phlebotomist. And then there were no further issues for the entirety of the.
Correct.
No further questions, Judge.
Any redo it?
Just so I'm clear, the vulgarities were directed by the defendant toward you and your partner, correct?
Yes.
And this insensitive statement that's been alluded to was actually you agreeing with
I was agreeing
a
with her.
verbatim statement made by the defendant.
Yes.
Any recross?
No, Judge.
Okay, thank you.
No further questions.
Any proofs? No proofs?
No, Judge.
Your Honor, people would move to bind over both as charged and with the added count. What's clear is that and it's kind of the first. An officer tries to accommodate the personal needs of the defendant, and in turn, when she's that appreciation is shown by vulgarity and various comments, and then when they attempt to place her in cuffs after behaving as she has, she then decides to take both officers to the ground. And I don't think letting a defendant or a person or an arrestee taking somebody to the ground is part of any standard handcuffing procedure. For those reasons, Your Honor, I think the people have not been burdened for probable cause purposes, both with respect to the count charge and proposed added.
As to adding the count, and then I guess your argument as well.
Your Honor, first I'll address adding the account, the additional count of the resisting obstructing. The officer did not appear today. Your Honor, the officer that did testify stated that she was not present during her OWI investigation. I don't think that they met the burden of probable cause, given that he hasn't appeared. The officer repeatedly stated a vague statement that vulgarities were directed towards her and her partner. They didn't bring any specific statements that my client made. So I would just object to that, for the record, Your Honor.
Brief response, Your Honor.
Yeah.
We're not charging
No, I
anything
know.
that happened during the investigation itself. We're charging with what happened in the hospital.
Right, which were facts known to the people at the time of charging. So whoever issued the warrant could have included if they wanted to, because they were known at the time. So I'm not, yeah, I understand, but I'm not gonna grant the motion this late. Preserve it for your appeal or upstairs, whatever happens. Now, as to bind over, anything further?
Yes, Your Honor, as the bind over, I think one of the statements made by the prosecutor was a slight mischaracterization of the evidence stating that my client took down the two officers. I think what was testified to was that they took her to the ground and then were able to put her in the handcuffs. Your Honor, from what we've heard from the one officer that testified today, is that my client behaved appropriately in such a manner that she was allowed to be taken out of the handcuffs. She was placed in a chair for approximately 20 minutes, sitting in the hospital, which is captured by both hospital surveillance footage as well as the body cam footage. Your Honor, I think that the officer made some statements that were inappropriate and agitating towards my client, and I think that they were insensitive and improper. Given that, I think that she had a reaction to those specific statements. However, she was quickly placed in the handcuffs. She complied with all the requirements in order to do the blood draw after a warrant was signed. The officer repeatedly stated that she didn't remember if she gave any verbal commands. So if there was some confusion going on, I don't think that there was any active resisting, given that she was, like I said, placed in the handcuffs very quickly after they initiated the decision in order to place her back in the handcuffs, Your Honor. So I would just object to the finding for this time.
Given the testimony included a statement by the officer that she pulled away while attempting to put in the handcuffs, that'd be sufficient probable cause in order for the court to find Lieutenant over on resisting obstructing. Is there anything further? Thank you.
Thank you, Judge.
Fine, continued. In the matter of People versus Foreman on 241884.
Good morning, Your Honor. Jane Wainwright on behalf of the people.
Morning, Your Executive Answer on behalf of Mr. Sporman, who is present in the jury box this morning. Judge, I would just briefly apologize to the court for being tardy. I had an examination that was set at 10:30 that I did not anticipate would run, and it did run.
All right. I mean, it's worked out.
Judge, it's my understanding that the people's primary witness is not here, received a late subpoena. The trooper who investigated is here. I believe Ms. Wainwright and I are agreeing to adjourn this so that their primary witness can be given a second subpoena.
That's correct, Your Honor. We got word from him. He received it too late. He had plans on going to the UP, so was unable to be here today.
All right, can that be adjourned? Is there anything further?
No, Your Honor.
No, Your Honor, thank you.
All right. And then in the matter of Cavalry versus Kaufman on 241107, parties that failed to appear, matter dismissed without prejudice.